I'm Karl Konrad, and today we're going to talk about the possibility of losing partner points after you've lodged your application simply by getting married. It's our constitutional right to marry in this country without the fear of being disadvantaged. Sadly, however, our international guests living here are forced to live by a different set of rules. On the 16th of November 2019, the Immigration Department brought in new laws which affected the 190, 189 and 491 visa subclasses. These laws effectively meant that applicants do not have the right to act freely, rather they are to be constrained and disadvantaged by doing what we all take for granted, to meet someone and fall in love. The new legislation disadvantages people who enter into a spousal relationship, such as being married or de facto, after receiving their invitations to lodge these visas. As single people, they receive 10 points, but once they have a spouse, they lose these points under the partner qualifications found in Schedule 60.11 of the Migration Regulations. These partner points and state territory sponsorship points are a time of decision criteria, meaning the case officer has to make a decision on the allocation of these points once your file is being assessed. All the other points in Schedule 6D, like age, English study, etc., are all time of invitation criteria. This means the points are locked in when the invitation is sent out to apply for the visa. Since partner points are the time of decision criteria, you can lose points if your circumstances have changed since the invitation was received. If you were single at the time of the invitation, then 10 points would have been allocated to you on the expression of interest system. However, if you marry or enter into a spousal relationship after the invitation, you will automatically lose these points regardless of the skills of your new partner. The only exemption to this is if your new spouse is an Australian citizen or an Australian permanent resident. The consequences of losing these points can be devastating because it could mean that you would no longer be able to meet the total points claimed in your expression of interest at the time of invitation. As such, in Schedule 2 of the regulations for all of these points-based visas, the visa may be refused. To claim 10 points for partner qualifications, your spouse must have been included in the expression of interest, nominated a particular occupation from the list, obtained a positive skill assessment for this occupation, and also have a valid evidence of competent English. To claim 10 points for being single, well, you just have to be single at the time of invitation. Or if you do have a spouse, they are an Australian citizen or an Australian permanent resident. Once you have a spouse after the time of invitation who is not an Australian citizen or an Australian permanent resident, then you will simply lose these 10 points. Now, if your new spouse had competent English before your invitation was received, then 5 points can be allocated. However, being allocated 5 points instead of 10 points may not save your application. If you don't obtain the score that matches the claimed score in your expression of interest, then your application can be refused. Traditionally, when the case officers come up with their own assessment of an applicant's score, and it is lower than what is the applicant claimed in the expression of interest, they are most likely to refuse the application. This disadvantage of marrying someone who is not a citizen or permanent resident of Australia is not by direct legislation, for of course this would be illegal. However, it comes in the form of a specific penalty. The penalty is the loss of critical points needed for the visa to be granted. These points can mean the ability to succeed or fail. In other words, the legislation is designed to crush the dreams and aspirations of the very young skilled people we are looking to attract simply because they have the desire to form a long-term relationship with another human being. This potential penalty will continue throughout the visa processing and also will include any appeal processes to the AAT and to the federal courts. This creates the absurd outcome where the visa applicant may be doomed for years never to fulfill one's desired company whilst an ongoing visa application or an appeal process is underway. Laws such as this undermine the integrity of the migration system. People will meet and fall in love, and that's the nature of being human. We cannot expect applicants to be able to stop this evolutionary process simply because they have applied for a visa. We also cannot expect applicants to make a difficult choice between love and visa grants. To fail in a visa application can have catastrophic consequences, so of course applicants are going to naturally hide the fact they have formed a spousal relationship. This means we have created a law in which people will feel it is unjust, and history has already told us what happens in these type of circumstances. As a country, we have placed an unfair burden upon those we're looking for to build our society. Let not us begin the journey by breaking their spirits and deny them of the partnership for even a nanosecond. Let's also not kid ourselves that in forcing them to choose between obtaining the visa and declaring the relationship, obeying unjust laws will take precedence. Instead, if applicants find love after lodging the visa, let us say, "Well done, and we hope you'll be happy together." But if that's too difficult for this government to proclaim, then it should give those skilled spouses a fair chance to be included in the application after it has been lodged. Let them demonstrate their skills and English competency when they are added, rather than penalizing the primary applicant for entering into a spousal relationship by refusing his or her visa. I'm Karl Konrad, and thank you for watching IMI News.